Mayor Gregory?
I'm here, sir.
All right. Commissioner Gillett?
Here, sir.
Representative Massey told me he'd be a few minutes behind, so we'll circle back to him. Mr. McGee?
Present remotely. Good afternoon.
Afternoon. Chief Monroe?
Present, sir.
Mr. Nicholson?
Present.
Mr. Preston?
Here.
Mr. Ross?
I'm here remotely, sir.
Mr. Sanders? Sheriff Scholler?
He's on.
Okay. Detective Thomas?
Here, sir.
Chairman Westerfield?
Here.
Dr. Wright?
Here.
Did I miss anyone, with, save the exception of Representative Massey? All good? Okay. Well, you guys know, I guess if you have any sort of travel reimbursements or anything like that, you all know sort of the procedure for that. So I won't belabor that again. If we have any public participants, I know we have a couple of people here, but I know they're also will be a part of the presentation later. But if there are any public participants in the room or online, thank you guys for being here. We'll obviously have a period at the end of the, the meeting for you all to comment or provide any insights that you'd like to. If by chance you're not able to communicate with us today, but still want to share your thoughts, you can always reach out to us with search warrant TF at ky.gov. That's again, search warrant TF at ky.gov. All right, at this time, you all should have the meeting minutes from the last meeting in front of you. I'll give you just a moment to look over them if you haven't had a chance. If everybody's okay with them, I'd like to make a motion, have somebody make a motion and a second to approve the minutes.
So
moved. All right, who are we registering as the motion? Lieutenant Bogart. All right, we'll do Lieutenant Bogart on the motion. Who's the second?
Cunningham.
There's Cunningham wins.
All right, there we go.
All right, all those in favor?
Aye.
The ayes have it. Motion minutes are approved. All right. All right, let's get to the new business. The meeting presentation of the serving committee.
I believe that we've spoken, and I believe we are going to allow Ms. Victoria Lopez, who's one of our guests. She has from the house. She has a story to share with us, and we'd ask her to come forward and present.
Hi, yes, ma'am. Thank you, Ms. Lopez. All right, share with us.
So first of all, I would to thank our law enforcement for doing such a tough job. I know that it's hard, and I know topics like this, make it even more difficult. So my name is Victoria Lopez, and I'm a person living in long-term recovery. I have been sober for 6 years, and in my past, in active addiction, I made some horrible decisions. I was actively using drugs, and what comes with that typically is selling drugs. And so I made some pretty poor decisions, and found myself in the center of a no-knock warrant being executed at my home. And full disclaimer, I take full responsibility for my actions. I know that, I put myself in that situation and I needed to be held accountable. So that day that they executed the no-knock warrant, it was me and my 3 small children and their father in the home. And it was late at night, and my 11-month-old was sitting beside me. Well, he was in that stage where he was, pulling up, and he was knelt down beside me, which was right beside the door. So when the door was kicked in, he was right there in front of it, and luckily he wasn't hurt. I'm not going to get into just a lot of details. I mean, it was a traumatic experience for me and for my children. Like I said, and I do acknowledge the fact that I too was putting my children in danger from what I was doing, my actions, in the home. And so I know that this is a difficult topic and a difficult thing to navigate, and there's really no perfect solution. But it's really worth looking at, and I really appreciate this task force for, taking the time and trying to make processes and procedures safer and all that. So, that led me to jail. That night did. Unfortunately, I was in jail for 6 months, and, I didn't stay sober when I got out, but, the silver lining, those charges that I got that night, eventually that's what led me to treatment for probation and parole. And I've been sober for 6 years now. So there's a silver lining to my story, and I'm very grateful for that. My children, they experience, they have some mental health concerns now, anxiety, depression, that can be accounted to a lot of things. But, without a doubt, that night was very traumatic for them and myself.
Congratulations on your 6 years of being
Thank
clean
you.
and sober.
Absolutely. Any other questions for Victoria? Or we really want to thank you very much for coming and sharing your story, and we appreciate that.
I appreciate you guys.
If I may, excuse me, but as Ms. Bentley was saying, we really do want to commend you for making a change. I know circumstances might have dictated a little bit, but you have to have the desire to want to. Certainly appreciate you doing that. And, your kids have probably seen some challenging things, but they've also seen the other side, which is what can happen when you decide to make a change and push forward and better yourself. And that's an example for them. You're a shining example for them. So I want to say that. And I know Isaiah House has been good for you. Well, and certainly want to make sure that we honor their presence with you as well. As it relates to it, I know we don't want to get into the details specifically, but do you recall sort of what time the warrant was served? Or?
It was about 11:30 p.m.
And I guess it was an actual no-knock, so you had no expectation.
Yeah, it was a no-knock. Yeah, no. Very surprised.
Is there, and I don't want to put you on the spot, but anything that sort of comes to your mind as sort of you've thought about this over, did this happen 6 years ago as well? Was that?
This happened going on 8 years ago.
Okay.
Yes.
Is there anything in those intervening years as you thought back to that night that you say, here are some things that, maybe you should have done differently, or is any of that something come to your mind?
I do. I think about it a lot. And I was talking earlier, like I said, there's no magic fix. I mean, I too put my children in a dangerous situation. I wish there was a way that they could perform these without the children, present if circumstances allow. It kind of after, it started, it was kind of a whirlwind. Sure. But, really that was, quite a scene for my little ones. But I just wish there was a way that we could do it differently, which my kids weren't school aged, so they didn't go to school, so that wasn't an option. But I wish that there was a process that we could, come up with or put in place for that, the children in the home, and think about the trauma and moving forward, their mental health future.
And so I don't want to go into the details either, if you don't mind me asking another question. I don't know why the police did a no-knock, but I guess my question is, was it that serious that they had to do a no-knock? Because we talk about circumstances in these committees on when it justifies a no-knock and when it doesn't. I don't know how much information you can provide, but if it was.
It was very serious. I'm not going to take away from that. And like I said, my children, it was a dangerous environment. That specific, they weren't in any immediate danger. I think that it could have been done differently. I do think it could have been done differently. Just the way that the process was, there was already, signed statements, and they had, the evidence and everything. And so I think that it, possibly could have been done differently.
Anything else?
Sorry.
No, go ahead.
Virginia, one of the things that's been talked about in recent years is whether the presence of social workers or non-law enforcement people are important. Was there anyone other than law enforcement present when this warrant was done? And do you think that would have made a difference?
Absolutely. I was talking with this gentleman earlier. There was not in circumstances there. It was just the law enforcement. I think that would be excellent if that, a social worker could be present. The social workers didn't come until about an hour and a half later to remove my children from the home. But I absolutely think, something along those lines would be super beneficial. I really do. Maybe even, like I said, there's no magic fix. It's a sticky situation. Each circumstance is different. But maybe even removing the children, if they're there, removing the children beforehand, having DCBS come and remove the children, which that's not going to be realistic in every situation if there's a super dangerous situation. But I think that would be very beneficial.
Ma'am, was it unusual for the children to be there at that time, or would have been fairly common knowledge that those children were likely to be there?
It was common knowledge. My children were always with me. So it was common knowledge. And, in the signed statement from, the buy from before, they stated that the children were there. In which too, I guess it could make it hard. And so they think my children are in danger. But yeah, it was common knowledge that my children were with me at all times.
Did their father get arrested that night?
He did. We both did.
I'm getting a better picture of what happened, or what I think happened.
Yeah.
Was there an explanation given for why a no-knock warrant was sought as opposed to just a regular one? I know you said it was serious when Miss Bentley asked her question, but I would hope, I guess anything is serious that they're going to serve at 11:30 at night. So not meaning to pry, just curious if there was at least an explanation given as to why a regular knock and enter wasn't available.
I was never given an explanation. I can see why, my co-defendants, his criminal history and previous charges and stuff probably played a big factor, in that, I'm sure.
Well, thank you for your honesty with that. And I do think the new legislation at least would give you an explanation, hopefully. And I hope there is always a reason for it. And it's apparent to whoever is on the other end of that.
Absolutely.
Anything else? Thank you again very much. Thank you to the Isaiah House for
Thank you for having me.
allowing us to come in, and we really appreciate everything, your honesty.
Thanks for doing this. It's a tough job.
At this point, I believe Detective Thomas, is she still on?
I believe she should be. She's still on.
Yes. She has put together some considerations. I think you put it best for her to present that.
Okay, that sounds great.
Can everybody hear me pretty well?
Yes, ma'am.
Yes.
I apologize. I've been sick. My voice isn't the greatest, but we put together some main considerations. The first one being training, which is obviously very important. It's something that needs to start for law enforcement officers right off the bat in the police academy, but then also we wanted to emphasize that it's continued throughout their career. It's probably going to be a annual or biannual sort of thing. And that was something we wanted to have more discussion on, whether it would be via DOCJT or another route. We also wanted to try and figure out a way to provide more information to the general public just about the general serving process of search warrants. I don't think the general public is super familiar with the process, obviously, and so they have possibly misconceptions in their brain of what we're doing, and they don't realize how in depth we actually go into them, and just really providing greater transparency when it comes to that. All police departments and agencies in the state of Kentucky should have a written general order or policy and procedures when it comes to search warrants. And when it comes to serving search warrants from a law enforcement perspective, obviously we're conducting a criminal investigation. I'm trying to build probable cause to charge someone with these charges. But before it even gets to that point, it's important to recognize these other goals that I have listed in the notes, because if we don't meet these goals, then the arrests and any evidence we have doesn't really matter at all. So those goals are a thorough and legal search, respecting the constitutional rights of all parties involved, to minimize the level of intrusion experienced by all parties involved, provide safety for everyone, and to also establish a record and document the actual serving process. We also came up with what we kind of coined as a search warrant toolkit. Because different law enforcement agencies in Kentucky look very drastically different. There's different amounts of resources, numbers of officers, and funding. It would be hard for us to try and push a certain mandate for a very specific way that every single search warrant should be served. So with that being said, we kind of put together a best practices toolkit that could be applicable across the state of Kentucky. It includes three main things: a threat assessment, a pre-execution briefing, and also an after-action review. So the threat assessment is something I think we've touched on through some of these meetings before with other groups that came in and spoke to us. But it's a physical document that's going to be filled out most likely by a supervisor. And this is going to be, if possible, several days before the day of the search warrant. And it's just a risk assessment where we can evaluate certain criteria in order for us to figure out the best way to execute that search warrant, if maybe we shouldn't be executing that search warrant, or if there's alternative measures where we can apprehend a target or a subject, whatnot. So on the document, it's going to have general things such as who the case officer is, the date and time that the document's filled out, And then it goes into the things we're assessing. So it's the suspect, the offense, weapons, a site assessment, and the time. The suspect assessment is basically you're going over everything you know about the target individuals associated with where you're executing the search warrant. Do they have propensity for violence, criminal history involving weapons? Are they known to be a drug user? Do they have any mental illnesses? History of resisting arrest, things of that nature. Moving to the offense assessment. What offense did they commit? Were they using a weapon whenever they did so? Is it a drug offense? Do we have a victim? Are there active arrest warrants for the individual we're going to serve this search warrant on? Next, the weapons assessment. What weapons is this individual known to have on their person normally, or that we believe for them to possess within their home? Obviously, if we know someone to have high-powered rifles in their home, we're going to approach that a little differently. Shotguns, handguns, even explosives. Site assessment is just going to be general safety threats when it comes to the actual physical residence that we're considering. I mean, do they have a fence? Do they have a mile-long driveway? Do they have surveillance cameras outside to where they're going to know we're there before we knock at the door? Potential for children, elderly, or handicapped persons to be there on the premises, or pets, dangerous dogs, things of that nature. The time assessment is going to be the time since the crime that we're investigating occurred, so we can determine exigency and how immediately we need to be executing the search warrant. The pre-execution briefing is going to have a physical document part as well as an actual briefing portion. The document is going to be a checklist that most likely a supervisor is going to be completing as well. They're going to be checking to make sure there's a detective or officer currently at the scene of the residence that we're going to be executing a search warrant on. If at all possible, and there's enough officers available, this is something we really wanted to push, is there should be someone at the residence prior to the execution of a search warrant. We call this person an I, and basically it's an individual that's going to be outside, most likely in an unmarked vehicle, conducting surveillance on the residence that we're going to be executing a search warrant on. And what that enables us to be able to do is several hours prior to us going and attempting entry into a home, we know who's coming in and out. Kind of what we touched on earlier, we would know if 3 small children had gone into the home. And I can say from my experience, we wouldn't execute, most likely. We would wait until we were able to pull those children out of the home, figure out a different way to go about it. But that helps us to kind of control different variables a little bit better. So back to the checklist. A photo of the target, suspect, and the location. Verifying what route we're going to take. Making sure there's necessary supervisory approval. Notifying communications radio. A list of all the officers that are going to be involved in the execution. And also making sure that every unit that's involved and is given an assignment is trained to do those roles. If that makes sense, every single person that's going to be involved in the entry team is going to have a very specific assignment. For instance, someone's going to be assigned the RAM to breach into the residence. Obviously, you wouldn't want to give the RAM to someone who has no experience. And that can even come down to smaller things, like if we know there's a dog in the home, one of us is assigned a dog pole, and they're actually pretty hard to use. And then we have the briefing for all the officers that are involved. So this is going to happen just prior to us actually going to execute the search warrant. Everybody's in a room. We are doing a presentation to make sure everybody understands what we're doing. The actual case officer is going to provide a case history so we know what our probable cause is for going to execute the search warrant. They're going to provide suspect details, photos, advise if they have any known physical or mental concerns, similar stuff to the target assessment I spoke about previously. If they have any identifying marks, tattoos, if they're going to be arrested immediately on site. We're going to provide associated vehicle information, the location of the operation, what route we're going to take to get there, and then environmental information, which is similar to the site assessment from earlier, which would include the geographical barriers, known pets, children, etc. Advising on what entrance the entry team will use and identifying other entrances that are at the home, nearest hospital, operational plan, what everyone's assignment is going to be going into the search warrant. And then we have the after action review, which will be post execution of the search warrant. And this is another physical document that most likely will be completed by a supervisor. It's going to have the general information such as what was the location of the search warrant, what time was it executed, associated case numbers, a list of individuals we encountered within the home, and a general synopsis of evidence that was located. And then also having a debrief with all the officers that took part in the search warrant so we can kind of talk about what went well, what maybe we could work on next time to be more efficient and more safe for everyone else. Our subcommittee also has talked about data collection, and when it comes to this toolkit and the different physical documents, kind of looking into what data or information is collected in those that we could keep and log for further analysis. If anyone else in the subcommittee wants to touch on anything that I talked about or bring up anything else, I think that was pretty much it.
Just, I would just echo an outstanding. I thought that was an outstanding presentation. And as we discussed from the serving committee general and so forth, is that although the courts of the United States and the state of Kentucky very seldom look at, in court cases, are they looking at the activity of the judiciary in a search warrant context? Quite often, they're not looking at the process of getting the search warrant in a case-by-case context. Thousands of times a year, the courts are looking at the execution of the search warrant. And so to a measure, there is a task force of 9 justices that look at the execution of search warrants multiple times a year on cases that are attempted to be brought to them. There is a task force of 7 justices that look at search warrant execution by way of the Kentucky Supreme Court on an annual basis. There are task forces of 3 justices that are judges of courts of appeal in Kentucky and across the 13 courts of appeal in the circuit courts of appeal in the United States. They're looking at how we execute search warrants every year. And I hearken back to the case of United States versus Banks, which was decided in 2003, and it had to do with the time frame from the time the constabulary knocks on the door and announces until the time that they breach the door. And in that case, the court said, the United States Supreme Court said, that we can't have bright line rules as to that this is too short a time, or that's too long a time, or this was reasonable, or that wasn't. We have to look at it on a case-by-case basis. So that's part of why we were somewhat suspective of not establishing bright line rules, but more in line with establishing a best practices list of toolkit, so to say, so that every individual agency that is executing these search warrants across the state of Kentucky and across the union have something to look at, because there are better practices than others. And we feel that what Detective Thompson has put together there and presented, or what Detective Thompson has presented, pretty well meets with a good toolkit to be provided to all the agencies across the state.
Thank you, Sheriff Filler. I am, and anybody from the group can answer this question, but I'm curious as to how many departments right now across our 120 counties utilize something like this toolkit. I mean, is it a large number?
We gathered several throughout the state, different threat assessments, things of that nature that we have actually compared to, and they're all very similar. Detective Thomas, is that correct? We've collected several across the state, from Covington to Lexington to Louisville to the League of Cities actually has their own outline of what it should be. So we've looked at a lot of those.
General, what we did, we gathered together some large metropolitan policies, standard operating procedures for it, and we also got the standard operating procedure that has been prepared and submitted as a model SOP by the Kentucky League of Cities and the Kentucky Association of Counties, available to the between 400 and 500 police departments across the Commonwealth and the 120 county sheriff's offices. And many of the things that are laid out in the presentation that we've made here today are included in KLC's and Kentucky League of Cities and the Kentucky Association of Counties model policy on search and seizure of residences.
I think we talked about this when you were in your transitional process. I think one of the things that the detective said that was really important is about providing more information to the general public. And we talked about, and I just want to revisit this, it's not a question, it's more of a statement of public service announcements and helping the public understand the search warrants are a hot button issue right now. And I don't think the public, I think everybody in here understands enough of the process, but PSAs to help the public understand search warrants and the search warrant process would go a long way in educating the public and often calming down all this misinformation that swirls around search warrants and what the police does and what the police shouldn't do and what's right and what's wrong. I still think anytime there's an opportunity to do public service announcements, whether they're very basic for non-law people or non-legal or non-law enforcement, is something to explore, not just with search warrants, but a lot of things that happen that your office is overseeing that can help educate the public. I think it goes a long way.
That's a really good idea.
General, with that, I believe Dr. Wright in several of our meetings, Dr. Wright has actually brought that up about informing the public. And I believe at one point, he said, that's something that we need to do. I think, is he available?
Right. I was about to just say that again now, that as a lay person who's been on this committee, first of all, I've been impressed with the amount of work that has taken place by my colleagues and the comments that were just made now about the many different things that various agencies throughout the state of Kentucky are already doing. But the challenge is that the average person, myself included, we just don't know anything about this. And so I really do wish there's a way we could get the word out. I think a lot of times when people don't know, they will always then assume the worst. But I really appreciate you mentioning again, and that is just such an important point I think that we would like to emphasize with you, General.
Thank you, sir. I'm sorry.
Mr. McGee has a question.
Oh, Mr. McGee, please.
Thank you. One, Detective Thompson, I appreciate the presentation you've done this afternoon. I did have a question about one of the things that you mentioned, and it has to do with the impact of the execution of the warrant on the residents during execution of a residential search. One of the things that I've encountered as defense counsel is the clients will come back and basically talk about how traumatic the process was, and there's really two things they always identify. The first is the condition of the residents after the police leave. And they've described it as everything from a hurricane to a tornado. The second is the fact that there's little information that they have after the execution of the warrant, and that the expectation would be that they would at least have a copy of the search warrant, if not the exhibit list that accompanies the execution of the search warrant. And for those who are unfamiliar with that second document, Detective Thompson can explain, usually the officers will complete an inventory of what is located during the search, and it'll identify the officer that found whatever the contraband was, where it was found in the residence, and sometimes it'll identify both the contraband and the time it was found. Many of the residents who've gone through a search warrant process will say that at the end of the process, they're lacking one of those two documents, either a copy of the warrant or a copy of the exhibit list. And then they all complain about the condition of the house. So was there anything discussed about trying to reduce the impact on the tenants by minimizing the amount of destruction or disarray of the home after the execution of the search warrant? That was the first question. And then really quickly, I had a colleague bring up something about a week ago that I don't know if the detectives and the judiciary had considered, but we have the technology now for real-time streaming during the execution of a search warrant. And is that something that law enforcement had considered using for the benefit of whichever judge authorizes the search, so that that judge or that judge's designee could actually watch the execution of the search, not the staging operation or the after-action review, Detective, but just the actual execution of the search warrant in real time? So I'll stop there and hear your responses.
Yeah, I'll start with the last part first. Are you saying that the judge that signed the search warrant would be watching a live feed?
Yes, ma'am.
Okay. Honestly, that's not anything I have ever heard before. So I haven't given it a whole lot of consideration. I don't know if my partners in the subcommittee have heard of it at all, but as long as it's solely just the judge, from my experience, I would have no opposition to that happening. I don't know if anyone else has a response to that in the serving.
I would be worried, Detective, I share your thoughts. I'd be worried about the performative aspect of that. No matter which way, I'd be worried about officers. I'd be worried about suspects. I'd be worried if everybody knew that was being broadcast live. That's an extra wrinkle in an already very dangerous and legally challenging environment. I'm not sure that would be wise. I think recording it is good. And everyone will remember that Senate Bill 4 requires that on a no-knock warrant being executed, you've got to have recordings of it. You've got to be equipped for that. And I think that's very good. I think checking that after the fact is incredibly good. And I think not doing it is malpractice. I think you've got to have that recording. Doing it live, though, changes things dramatically, and I'm not sure it would do that for the best for anybody involved, suspects or law enforcement or the legal system.
Mr. McGee, the only reason that I would think that you would have it streamed live would, in theory, be so the judge could at some point jump in and say, stop. And I don't know why you would ever do that, and why I would feel like by watching somebody's body cam, I would suddenly be empowered to say, you got to stop. And if that's not the purpose, then recording it suffices. In other words, if it's just there. So
I would say, Judge, it's not so that, I'm sorry, I didn't mean to interrupt, Your Honor.
I'm done.
No, it's not so that the judge can participate in the investigation. It's so that the judiciary can see how these warrants are being executed and can see how consistent with the authority that the courts provide these officers, the actual execution is. So this is a learning tool for the judiciary and not so much a performative art for the detectives, because frankly, law enforcement is going to execute the warrant the same way, regardless of whether it's being recorded or being live streamed. This is to help the judiciary learn about the impact of these warrants and the communities that are actually being affected by the execution. That was the reason why I talked about a live feed that's secure just for the judge or that judge's designee.
I think, if I can, Mr. McGee, I respectfully disagree. I think anytime you live broadcast, if you talk to legislators, if you talk to judges, one-on-one conversations are wildly different from when they're on the court, when they're on the record, or when legislators are on the floor and they're in a committee meeting. Once it's being live, that changes things and it changes people's demeanor and temperament. It will do the same thing for law enforcement. So I think that I disagree with you on that, but I think there's a huge limitation. Even if you could live stream, even if the technology and the bandwidth was there so that the judge could see a live stream of it, if you've got 4 or 5 officers, they're all making split-second decisions based on the environment and what they're encountering in that moment, interacting with one another. I don't know how in the world a judge would be able to understand and comprehend that environment and that situation by looking at 4 or 5 live streams all at the same time and appreciating the size of a room or the amount of risk based on what they see or what they think they can see in a lower resolution thing versus the officer's vision. I appreciate the intent of what you're suggesting, but I think that presents a lot of it introduces a lot of ambiguity for the court when a recording is as good as you can get without actually being present.
Mr. Westfield, I agree with you on that. And I think one of the issues that we're forgetting, though, is especially down in Eastern Kentucky, we don't have the infrastructure in the state to do live streaming. I mean, most of the people don't even have broadband in Eastern Kentucky. So, I mean, this would be impossible to accomplish. I think Senator is right in having the body-worn cameras and having the recorded footage available, Mr. McGee, and that way they can, review it. But as far as live streaming, this state is not even close to being ready for that.
If I may, I think in regard to live streaming the search warrant to feed back to the judge that issued the warrant, I think that we need to look back at the 4th Amendment to the Constitution and the 10th Amendment to the Kentucky Constitution and what the judiciary's role is in it. And it's a role of a disinterested magistrate to determine if there is probable cause for the government agent to go look for evidence. And if we take and start putting that judiciary into the role of being the referee on scene, and much akin to a referee in a boxing match or a basketball game or something of that nature, that takes that judiciary out of the role of being disinterested. They then become, it would generate them to be an interested party in the process. And again, what the Supreme Court has ruled many times is that the reasonableness or unreasonableness of the process of executing the search warrant is to be determined in the context of the 4th Amendment to the Constitution and the 10th Amendment to the Kentucky Constitution. And from, as Graham versus Connor points out, from the viewpoint of the reasonable police officer that is there at the scene, not with 20/20 hindsight. And so I don't know that we could get into a position of fairly having referees on scene to call out. The idea of recording it seems to me to be a very good idea, and then it can be assessed as to whether people unreasonably destroyed property or people unreasonably left things in disarray or so forth by the courts as they review. Anytime somebody has counsel that wants to have it reviewed, or whether that be in the context of a suppression hearing or a 1983 action subsequent thereto.
And I'll just point out, as the guy who probably screws things up more than the rest of y'all, I always think about what happens when something goes wrong. So as an example here, if we were to say that we think it is a good policy that, let's say, if a search warrant is going to be executed on a residence, it should be live streamed to the judge who authorized it. And again, I'm not necessarily on board with that policy, but I'll say, so what happens when they test that, when they get close to the house and it doesn't seem to be streaming, or the judge says, I'm having trouble with my laptop getting, or you can't wake the judge up because you're getting ready to execute it at 1 a.m, the judge is freaking asleep. There's lots of ways that things could go down where that really didn't work the way we thought it would. And this, more so than many things, is something that could gum things up. And then what do? Do we say, well, the evidence that was obtained is now tainted because the judge wasn't watching it as it was happening? Or do we say, well, it's not that mission critical, we could still use the evidence? Then you have to say, well, then why were we doing it if it wasn't mission critical? So again, I like the idea of recording it and it being available for anyone. And as somebody pointed out, the judge is really, once they've approved it, that particular judge really doesn't have anything to do with it. It's whatever judge that case would subsequently get assigned to, or whoever's reviewing this sort of stuff on an ongoing basis, as we hope someone will. But to say that judge should be looking at it doesn't necessarily, there's not necessarily a good reason to do that with that particular judge.
The only thing I would suggest in response is this. Essentially what we've heard is a lot of concern about judges watching how the sausage is being made. That's what it sounds like. That, well, it's a problem if the judge is seeing it because then the judge will want to intervene. Well, that's easy enough. Judges don't have to intervene. They're just
the only reason to do it live is so the judge can intervene. If it's not to intervene, then watch it later as a recording. The only reason to do it live stream is to interject yourself. If I'm not going to be told to interject myself, I'll watch it the next day or the next week or whenever.
Okay, which is fine if that actually happens. Because here's our concern as members of the community. And honestly, this is what it really comes down to. This entire task force, as I understand it, was designed to kind of ameliorate the concerns of the community about how warrants are obtained and how they're executed. Well, it all comes down to the judiciary. It comes down to the training of the officers, certainly, but the judiciary is the only entity that can authorize these search warrants. And at some point, judges have to understand what they're authorizing. If you don't see it happen, if you don't know exactly what it is that you're essentially turning loose on the community, and I don't want to describe it in negative terms, okay, but if this is having a real impact on people in our community. If you're going to authorize that, then you should at least know what it is you're authorizing without the academic 4th and 10th Amendment arguments. I'm talking about where the rubber meets the road and how these impact members of affected communities. If you're never seeing it, or you're getting it piecemeal in the context of suppression hearings, then respectfully, I don't know that judges really appreciate the extent of authority that's granted with a search warrant. The technology is there for judges to see this and to actually observe it. Now, if judges are going to go back and watch all the streams after the fact, great. That's a learning process for the judiciary, and maybe it'll give judges something to consider in authorizing warrants. But to say that, well, we're concerned that it'll impact the way people behave on film or on digital, that has its own implication, candidly, about the role that everyone's playing in this. Not to beat it to death, those were some of the things that I was told to talk about essentially as members of the concerned communities.
And I will simply say as a judge, even if I saw something happen during the execution of a search warrant that to my sensibilities was bad, and you can fill in the blank with lots of different things. You've enumerated. I thought they trashed the house. Why did you have to go through there and make it look like a tornado had come through? I don't like that. Or I come in and they're being vulgar towards these people, treating them like they're trash, or they scare kids, they kids or something like that. That Charlie Cunningham would say, don't do that. But guess what? The next time somebody shows up with the same equivalent affidavit for a search warrant, I'm still going to have to sign it. I don't get to say, now, by the way, officer, when you go to execute this one, here's a couple of things I want you to not do. That's what this task force can do. I mean, somebody alluded to the Supreme Court being a task force. No, they're not. They don't make policy. They simply say, bounds or out of bounds, period. We hopefully will help to move the inline to where we think it ought to be and set policy. But as a judge, it doesn't matter how many horrendous executions I see, I'm still obligated to sign it if it meets probable cause. Now, I tell you what, I do like your idea though, is to gather up what I'll call a horror show of half a dozen body cams where they are doing things like that, and do it for a continuing judicial program, so judges do know here are some things that have been happening in Kentucky with the execution of search warrant. There's some really bad stuff. Although, again, I'll just say that doesn't really change my ability to deny somebody a search warrant if they've put in the affidavit what amounts to probable cause.
That makes sense.
I do like it. I do like it I'll mention it to the education, that might be something good for a CJ program. We'll have to figure.
And I would say, Judge, not just for judges, but for law enforcement too. I mean, people need to be aware of just how badly they go wrong, and they do.
What do we call that? CP, continuing police education, or again, it's part of your all's recommendation. Actually watching it, I remember we had one thing once on basically probable cause to stop people in a traffic context, and they had basically lawyers and judges acting out roles, and of course it was, they took it to extremes, but it was it really stuck with you because you actually were seeing, as opposed to hearing somebody talk about something, you actually saw it playing out, and to see it play out for real, I think would be very impactful. So we could put it to use in that way.
All right, any more thoughts on this subject? Mr. McGee, thank you for raising the topic and expressing obviously concern that you've heard echoed to other folks that you've talked to in the community. So I appreciate you bringing it to the table, and know that it comes from a place of just wanting to see accountability and making sure that as these search warrants are administered, that they're done in a way that represents the values of the Commonwealth. So I understand that. I also think that you recognize some of the logistical challenges of having real-time streaming, whether it be because Eastern Kentucky doesn't have perhaps the capability to have a stream that is fast enough to meet the needs of watching in real time, or even some of the, as Chairman Westerfield noted, that there will be an element of either chilling the search warrant process, or would have the process work in such a way that it is, performative. And so, but I do think that, we landed at a spot perhaps where, some more education can be undertaken, or perhaps a part of some annual or biannual training, so that, there's the do's and don'ts, if you will, of administering a search warrant. So thank you for that robust conversation. And is there anything else that we want to talk about as it relates to search? Yes, sir.
I've got a few questions for the committee, but actually, could we go back to Mr. McGee's first question, which I don't think was ever addressed, which is the damage to property, because we're very interested in that as well. Are there recommendations, are there best practices when it comes to how property should be treated? We too have heard many concerns about the condition of property after a search warrant is done. And so this could be anything from damage to the entryway that's from the entry, or damage to property, or just basically ransacking of property. So how's that viewed?
Well, again, there's innumerable cases that the United States Supreme Court has dealt with damage to property. U.S. versus Banks is one of them. I just recall that because I just reviewed it over the weekend. But in that one, the defendant in that case, he filed an action and so forth, and he complained of the damage done to his door because the police, the FBI in that case, they waited about 15 to 20 seconds before they broke the door. He said he was in the shower. However, the court determined that someone could hear the knocking on the door from the front to the back of the apartment. But he complained of the damage to the door. People complain of the damage done to property all the time, and I would say my point about the United States Supreme Court being a task force, they set policy. When we have 1983 actions where cases are brought and the Supreme Court is making the decision that the police acted unreasonably or they acted reasonably, that is a basis for which by which policy is set by executive agencies all across the country. That's the manner in which I was referring to them being a somewhat of a task force. And the best lawyers across the country go before the Supreme Court. The best lawyers across the Commonwealth go before the Kentucky Supreme Court. And when somebody, again, I as an executive with the sheriff's office, I do not want, and I think constitutionally we should not have police officers damaging property any more than necessary, than reasonably, and reasonable is always in context, but than reasonably necessary. And if one of my deputies does damage property that is more than reasonably necessary, then the people that own that property, they get to make a claim to the sheriff's office. And if I disagree with them and they still feel that it was damaged too much, they can file a 1983 action for one. And as you know, as the lawyers in the room know, as long as they win $1, the lawyer that took that case is going to get their lawyer's fees paid. So they just have to win one. They don't even have to win $1. If they win 25 cents for the damage, the lawyer's fees get paid. So those cases are brought with great regularity in the United States District Court, claiming violations of 1983, and an unreasonable damage to somebody's property would constitute a basis to file a 1983 action. To your point, ma'am, about public service announcements or public service education. I remember hearing about 1983 in law school, heard about it in college. I don't remember getting anything about Section 1983 of the United States Code in high school, but the public needs to understand and needs to be taught, given the information about what remedies are available to them and what the process is. I agree wholeheartedly with that. And I don't know if that answers your question from my perspective or not.
It does a little bit, but I certainly hope we're a task force. As I understand the mission of this task force, it's to come up with best practices and possibly recommendations for legislation. I certainly hope our job isn't simply to analyze 1983 actions. And if the defendant loses a 1983 action, then no harm was done. Because 1983 actions are complicated legal cases that gets into qualified immunity and all the possible defenses to the 1983 actions. So I don't think that's even a place to look. I would say, I'm interested when you said that they could file a claim with your office. That kind of gets what I would like to hear is, what are the local policies? Not can they sue me and I'll lose, but if a deputy busted in somebody's door when they shouldn't have, or they busted in the front and back doors when they could have only gone in one door. If there's gratuitous damage done, what are the policies for making the person whole if that was more? Is there an appeal right? Should there be a civil action that's not a 1983 action, a small claims action for $800 in damage?
Well, those are available as we've said here. They've always been available. Small claims actions are available. People, just because somebody, works for local government or state government or the federal government, doesn't mean that they can't be sued for a negligence claim. I mean, I practiced negligence law for 38 years and I've sued governments for negligence, not for tort actions, not just 1983 action. And for those of you that aren't lawyers, a tort action is when somebody does a civil wrong to somebody else such as damaging their property, that would constitute a tort. And people have had that available since before I went to law school.
Those are difficult to make, and those are time. I guess I'm asking about policy. Is there a policy for how to limit the damage, and when those limits are exceeded, what a person's remedies can be?
I have a policy at the Fulton County Sheriff's Office that I do not want anybody associated with our office to mistreat any person in the Commonwealth. And so but do I have a set policy that says, don't do this or do that in terms of, or what the process is to make a claim, other than people can come and make a claim. And then if it seems like it's that we had, anytime somebody makes a claim under KRS 15520, that one of my deputies has done something improper, we're going to investigate that. And heck, if somebody comes up and tells me in the back alley that somebody did something wrong, I'm going to look into it.
All right. Anything else?
I have some other questions beyond that. I didn't know if anybody else wanted to respond on that. I've got, I guess, 4 questions. This isn't necessarily on the recommendations, but since we haven't really talked about the execution of search warrants, so for anybody on the committee or any of the other law enforcement people, the risk assessment talks about the only reference to time was the time since violation occurred. I just wonder, how is the time of day considered? When Ms. Lopez talked, she said that was done at about 11 o'clock at night or 11:30 at night, I think. I think of search warrants as being executed in the middle of the night, and many tragic ones have occurred overnight. How is that weighed in the consideration of when a search warrant is done? Is it only when necessary, or is there a strategic advantage viewed to serving a search warrant overnight? And here I'm talking about a residential search warrant of an occupied house.
I can only speak with regard to the search warrants that I've been involved with over my years of preparing them, arguing suppression hearings, representing agencies in 1983 actions, and then a much less number of ones that I've been on the execution of. However, the whole purpose of the search warrant, from my perspective as the sheriff, is we're looking for evidence of the crime, that we have taken some evidence that we have probable cause of, that this evidence exists at a place, to a judge, and the judge has signed the warrant. So I'm looking at 2 things in that regard, 3 things. 1, I want to make sure that we don't violate anybody's constitutional rights. Anytime, always, never do we want to do that. Number 2, the safety of everybody involved. Number 3, the likelihood that we are going to obtain the evidence that we think exists. Okay, so if somebody is telling me as a supervisor that, well, there's a better chance it's going to be there at midnight tonight than that it's going to be there, or if there's some exigent reason that we need to do it at midnight, okay. But generally speaking, I'm a believer that daytime execution of warrants is good. Now, I don't it seems over my years, back in 1989, 1990, 91, it always seemed like, just anecdotally, that it was midnight when somebody would come, because I prepared all the search warrants at my kitchen table. I would sit down and I'd be preparing search warrants and then call the judge, and off they'd go over to the judge's house. I always wondered why we didn't do those at 2 o'clock in the afternoon, prepare those search warrants, but there was reasons that they argued to me that it's because the deputies that do that type of work are out at night and so forth. But daytime in my agency is the default time to serve the search warrant. If somebody wants to serve it up in the night, I want a reason why.
What percentage of search warrants would you say are surprise search warrants as opposed to part of an ongoing investigation where the search is not a surprise?
Surprise to whom?
The person being searched
I couldn't answer that.
The subject, because I know some search warrants are, I'll go get a warrant for a phone, I'll go get a warrant.
It's impossible now that that's, yeah. Surprise search warrants being.
I'd have to know the mind.
Which one's the majority? That's because I don't even know, are most search warrants where someone doesn't see it coming? Or are most search warrants, we're already investigating this person, but I can't do this. It's a violation of their constitutional rights, so I'll go get a search warrant to search their house, their car, their phone, or whatever.
Well,
Is that which one's the majority?
Most of the time, they don't know it's happening because most search warrants track cars or cell phones or to get into cell phone data or Facebook data. Statistically speaking.
Yes. I would agree with the judge. Most of the ones that I see.
Can you say that again? Can you say that again? I apologize. Can you say that again, Judge Cunningham? I'm sorry.
I just said that statistically speaking, the majority of search warrants aren't even for someone's residence these days. The majority of them are to track a cell phone, to look inside of a cell phone, to track a car, to see and to get data. And those are almost always unknown to the person. In fact, they're almost always sealed because they don't want the people you're getting that data from to let the person know that, oh, by the way, we shared your information with the law enforcement agency. So but I think Damon's probably wondering about situations where you're going into someone's residence. There, I wouldn't feel comfortable hazarding a guess on that.
You all think?
Again, I agree with the judge. I don't feel comfortable guessing percentages because there's no way to determine it.
I guess I don't understand the answer. I mean, I'm not gonna cross-examine you on whether it's 25% or 35%, but are a majority of searches of people's homes surprises to the people in those homes? Or is it situations where they already know they're under investigation, maybe they're even already in jail, but to go to the house, you need to have a warrant, so you get one and you go?
I couldn't answer that without knowing the mind of the various criminal suspects that we're dealing with, and I don't know their mind. So whether they're surprised when somebody comes and knocks on the door and wants to come in to search their house, now I have no way of knowing whether it's a surprise or not.
Well, I can tell you as defense counsel, in 26 years, I can count on one hand the number of clients who knew that a warrant was about to be executed. Even if the warrant is built into the investigation that the officers are doing, it's rare that a tenant is going to know that a warrant's going to be executed in their home.
Yeah, Ramona, that's my sense too, but I also know that at times someone could already be in custody, but their home has not been searched, or the ongoing investigation, something else comes up and maybe they need to search the house again and they go back and get another warrant. Those are what I'm talking about. I'm not talking about somebody's sitting at home watching TV saying, I can't wait till the police get here to search. It's more that there already is something going on.
Right.
I've had situations where people get arrested at a motel and they'll arrest them and they'll take them in and then they'll come and want a search warrant to go look inside their car, to go look inside their motel room. In theory, those people know, but in truth, they don't even know because they're stuck in a jail. They really don't know that's about to happen.
Yeah, and so with Sheriff Scholler, I maybe it's my use of the word surprise. I don't care whether the human knows it or not. It's a point, is it part of an ongoing investigation in which an arrest has already been made, the person's already on notice, and then as part of an ongoing investigation, you do a search, or is the beginning of the process that you're doing a search warrant, and this is the first time anyone would be on notice that they're even suspected of anything. So it sounds like most searches, and maybe my question's confusing because the former ones don't happen very much, which would be the answer to the question. So most residential search warrants are the beginning of the process. Is that what it sounds like?
I would not agree with that because we have, in our narcotics investigations, for instance, we have like 3 different levels. levels of tasking police officers with. Street level buy. I see somebody who's making a sale or purchase of drugs, and I deal with that. Or I find drugs in a car that a patrol deputy finds just because somebody violated the law, and when we stop, we smell marijuana, or we see some evidence of drug use. That's street level. Then there's mid-level where we would maybe be dealing with that person has advised us that they buy their drugs from somebody. So then we're starting an investigation on it. And it would be some point off in the future. It wouldn't be that we would, what you used to see on some cop show on television where they would get one guy and then they'd start making the telephone calls and start rolling up 3 or 4 or 5 people. I've never seen that in my career where it worked that way. But we do investigate later. It's not that we take and just, you know what, I think maybe we don't go in a room and just think, I think maybe we have enough to get a search warrant on old Joe over there. So let's go see the judge and see if we can't get a search warrant, and that initiates the investigation. There is typically some investigation going on prior to the seeking of a search warrant.
No, yeah, I get that. That's not what I meant by start. Okay.
Damon, I do see a fair number of search warrants that come from police officers going to arrest somebody on an arrest warrant, seeing things, asking for consent. Consent gets denied, so they go ahead and arrest the person and get a search warrant in the meantime, or they hold the person there. So I think there is probably a fair number where they technically know that it's coming, but when the day started, the police officers didn't even know that a search warrant was coming.
No, but Joe, that's exactly what I'm talking about. And I think I've probably been confusing in how I've asked it, but that's what I'm talking about. Because in that case, I'm not talking about the investigation starting, but the person's put on notice of their charges when they have an interaction with police. Maybe police ask for consent, it's turned down, and then you go get a search warrant. That's exactly the kind of case I'm talking about, where the search warrant is after the interaction, as opposed to the search warrant being the first interaction with the person. And so I get it's all case by case, every case is different, but I guess I'm just asking, in your experience as law enforcement, that's the minority way that it happens, right? Most of the time, the search warrant is the first interaction with the person. Is that correct?
I was saying, I think that it's they're more equal. I think, as the sheriff was saying, a lot of it depends on who the officer is. Road units are pretty much always going to be, it started with an arrest and went from there. And then your more drug information where they're building a case, it's going to be more often the surprise.
I was going to make a comment that kind of pulls together some stuff Detective Thomas said and Ramon said and Sheriff Scholler and Mr. Preston, and that's this. A lot of what people think they know about the search warrant process comes from watching TV. And this idea of what happens if they come in and trash a house, there may be as much misinformation about this process because on that point as anything else, because as Sheriff Scholler says, if somebody comes in and trashes a house needlessly, it's always been my understanding from the people I've talked to in law enforcement about it that law enforcement has to pay for it. But if people don't know that, kind of to Ramon's point, if they think they get to come in and they've trashed my house and I don't even ask what I can do about it because I saw it happen on TV, I know they just get to do that. It would be very important, this idea of educating. I don't know how we do it, but I like the idea of trying to help the public understand, because that's the kind of thing that would infuriate folks if they actually believe that law enforcement gets to, if they're mad at you, just come in and trash your house. And we who are involved in the process understand that's really not the law. And there's a severe financial penalty that would follow if you do that. But if people don't know that, then that's bad. And again, I'm not sure what the fix is. I like your all's idea that we need to get more out in the public to help them understand. I'm just not sure how to do that. I'd call an order and say, would you stop showing it where they trashed the place when they hit the house, but law and order doesn't care what I think.
Just a couple more questions. We talked with Ms. Lopez about the impact that a social worker may have. Are there law enforcement agencies that regularly include non-law enforcement presence during the execution of search warrants, like a social worker, if you know kids are going to be involved, or similar professionals?
After the fact, absolutely, just like she said. Now, maybe not an hour and a half later, but yes, if there's going to be children involved, yes, there are law enforcement agencies across this Commonwealth that do utilize those agencies, the social workers, things like that, to get involved. They're not going to necessarily be on the search warrant. They're going to be notified that, hey, we're going to be calling you to come in. So, you know, the time frame of, you know, the response time and things like that is going to vary between the agencies, locations, things like that. But yes, I think I could honestly say on a regular basis that there are social workers involved in cases like that.
Is it simultaneously or is it?
No.
And I think that's maybe what she
right.
alluded to. I think that's what they're going to start doing in Jefferson County. I don't know. Is having social workers and other people work alongside police instead of after the fact, as opposed to, you know, hours later or days later. Right.
And I think generally what we're doing is, you know, we're notifying them, hey, you're on notice that this, you know, we may need you, because we don't know what's in there, you know, again, going in, but, you know, letting them know. So he said the hour and a half, couple hours later, response is probably not indicative of general what's happening. It's generally quicker than that, but obviously they're not going to be there in executing the warrant.
I just wonder, and I don't mean to interrupt you, I just wonder if those services have been in place simultaneously in her situation, would it have less impact on kids? We don't know.
We don't.
But maybe that's where we need to move toward, is making sure those agencies are side by side with the police, especially in situations where we know there's children or elderly or things of that nature where it could have a traumatic effect on someone.
There would need to be a safety protocol. Obviously, we're not going to have a social worker on the front line.
Right.
But if they could be in a safe location where they could be there within 10 minutes, that would certainly be nice. And
I think it just depends on where you're at in the state. It depends on the availability of them and all that. Exactly.
Yeah. Last question I have, and I know in advance, this is probably going to be another one that is so fact specific, maybe you can't give a general answer, but how many officers are used to execute a search warrant? Obviously it's going to vary. So let me give you an example. Let's say it's a residential search warrant that you expect 3 people to be there. It's not going to be one, right? It's going to be more. Obviously, it's going to have to do with the resources of local law enforcement. There's a lot of stuff going on. Let's assume you've got the resources you want. What I'm trying to get a sense of is in the execution of a typical search warrant, whatever that means, typical search, is a strategy to overwhelm with presence? Is that a strategy that's used, that there would be 20 officers there?
Yes. Yeah. I'm going to comment on officer tactics.
Okay.
What?
Then how?
I'm sorry, I didn't understand what you said.
There's so many variables that can be included in that. There's not a perfect answer. We don't want to let out a lot of the tactics that we can use.
If we're looking for tactics, I think aren't there some bare minimums that police officers function under?
There, in an absolutely sterile, if you came to my office and said, I want you to come search my house, go see if a judge will give you a search warrant to search it. And then I was just absolutely certain that I don't have any danger going over there because you and I are next door neighbors or something like that, or it's a consent search. I want to do everything that I can not to overwhelm you or anything. But by the same token, going towards what folks said, we're not going to, I want everybody to be safe. Yeah. And so whatever number it's something that I can't, it is so fact specific, but the numbers have to do with safety and processing information. I've been involved where we had search warrants and we got $2 million. It takes a long time to count $2 million. So the more people I could have had there, the better. We would have been happier with more people just to count the money.
But I think my question is, I'm looking at it from probably an urban standpoint. If you know you're going into a place that has 4 gang members or known drug dealers or whatever, do you show up? Is there a minimum standard of what you show up with as far as resources, or is it whoever's on duty?
I believe the minimum standard would be whatever we can take into, whatever we determine the safe number is to maximize everybody's safety. That's what we want to do. But in terms of, is it 1 or 5 or 15 or 30? There's no way.
I'm not asking for police processes or techniques or anything. I'm just trying to understand, because I believe every officer deserves to go home at night to their family. So I'm just trying to understand, in your huddle and when you get this process going, do you say there's 4 people, we know they have guns, we know they're this, we know they're that, we need a minimum of 10 people? That's just me. That's me asking as a lay person, but I understand your answer.
And again, going back to the toolkit that we have sent out, one of the things that we want everybody to consider is the threat matrix. And that threat matrix has to do with what the level of reasonable concern we have as the a police department, a sheriff's office, when we go to that place.
I guess I understand that, and I would think when you talked about reasonable concern, getting at tactics, but I think of that my view, if I were in law enforcement, is I would want to round up. I'm not trying to come up with the exact number that's going to be exactly safe. I'm going to want enough where I know where I feel have security that I'm going to be safe. Not this is not somewhere I'm going to want to pinch pennies and say, well, I think this is enough. I'm going to want enough. So I guess maybe a good way to ask it would be, if you've got none of the threats, or you do your threat matrix, there's no reason to think anybody's going to fight police. It's a residential drug case, but every residential thing's got a risk. What's the minimum number of officers that you think you would ever send? Would you ever send 2 people to execute a residential search?
I don't think we can answer that question. I can't answer it. I can't. Because just as you said, the risk changes. It changes by the time of day. It doesn't have to do with, I don't know, you don't know me. We don't know each other, but I don't have any idea whether you are, I don't know what goes on at your house.
But I guess that goes to my point. So what's the minimum?
There is no minimum.
Well, there is a minimum.
No, there's not.
Would you ever imagine sending 2 people to do a search warrant when you don't know who's there? I would assume the answer is no. We would never go send just 2 people.
So here's another one.
Where is
if
that?
I did have if I did have a minimum, I wouldn't tell you what it is, because I think that puts people at risk. I would not say what any minimum would be, or a maximum or anything like that. Every individual case has to do with trying to see that everybody is safe, and it would be inappropriate for me or I think anybody to say, here's a minimum or here's a maximum.
There.
Anything else?
I think that's it.
All right. Or anybody else have anything for the serving committee? Well, thank you all for the presentation. Obviously, it's engendered a lot of good conversation and questions and inquiries, so appreciate your work. And Detective Thomas, thank you for leading the conversation and sharing your thoughts. And I think that toolkit is a really good starting place as it relates to perhaps some recommendations that might come out of the serving committee. On that note, we are now going to break out into our subcommittee meetings, and as many of you all know, our next meeting is actually going to be, next Monday, November 22nd. And the idea is that today, go into these subcommittee meetings and start formulating your recommendations. And once you formulate those recommendations, we can then have a longer conversation on November 22nd about those recommendations. So you go into your subcommittees today, formulate the recommendations. We'll come back on November 22nd, talk about those recommendations all together. And then the idea being that December 9th, I might remind you that November 22nd is an additional meeting so as to have more opportunity for conversation. The idea is that we'll come back finally on December 9th and vote essentially on those recommendations. Now, it's my preference, my view that that vote should be unanimous on those recommendations, meaning all the recommendations that ultimately end up in whatever material that we publish are a unanimous recommendation, meaning everybody has agreed on them. Now, as an aside to that, it's my judgment that perhaps there will be other things that some folks on this committee might say, you know, we appreciate these unanimous recommendations, but maybe these are some other things that need to be considered. So all of that can go into this published material that we put forth, meaning we have unanimous recommendations, and then if there are a group of folks or an individual that wants to pin their name towards additional ideas, I'm amenable to making sure all that goes into the same report. It just wouldn't be the unanimous recommendations of this task force. So with that said, take any questions that you have on my sort of proposed thought about unanimous recommendations and having a section as well for additional commentary for folks that might want to share some more ideas with the public. Happy to entertain any questions you have on that before we break it to our subcommittees. If there are no questions, then I'd say we should probably come back here in probably 45 minutes to an hour. Is that okay?
Yes, sir.
All right. Sounds good. Thank you, guys.
I tell you what, that's the greatest thing since sliced bread when you're in a hurry.
I'm telling you.
Not have to take your shoes off and all that.
Global internet. You haven't done one point.
I haven't yet. I'm probably going to do it. I didn't, the last 2 years I've gone out of the country because of the pandemic. If you check your calendar, just let me know.
Okay. So you just sent me a text.
It's the 13th. December.
So give me, she got in the middle of November 30th. Where you going? Me.
All I know is I went to an event last week.
I don't get invited. It wasn't a party.
No, I'm kidding. It was the
I tell
opening.
people he's like my son, but he doesn't show up enough.
It was the opening of the Northern Kentucky AG's office.
Oh, that would have been fun.
What a great space it was.
You could come. I didn't know about it. I'm not on the list. I guess I'm on the list. Let's go see you later. I know you would. All the flags I take.
Unbelievable.
No, it was a good event. Seriously.
No, I don't have a crystal ball.
Now, when's Mackenzie?
She's
January?
due in January, but my 60th birthday is in 2 weeks on the actual birthday.
I don't need this. I don't need that. All right, I think we'll go ahead and, yeah, I think so.
Yeah.
Do we have everybody or?
Damon.
He had to leave.
Oh, he had to leave. Okay.
I have our comments.
Looks like he picked up his.
All right, well, let me make one additional comment on the remarks I made earlier about the recommendations. I hope that obviously we'll get in this when you all make your presentations here, brief us on what you all discussed, but the idea would be that perhaps sometime during this week, meaning before the 22nd, if you could get your recommendations to Blake Christopher so that he can assemble them and make sure that we are ready and prepared to discuss those recommendations. So that's the only additional comment I'll make as it relates to. Okay, so we will start with the, Dr. Wright, do you have a question?
Yes.
Yes, sir.
General Cameron, the comment that you made before the break about, that we would have all the recommendations and that we would hopefully have unanimous approval on the recommendations. I agree wholeheartedly with that. Here's my comment. Is it possible that in addition to the recommendations that there be I'll call it a statement or something that's said that's a general comment about, the task force has met. The task force has done this and this was important or something to that effect. The reason I say that is that I can imagine that once the report is issued, all of us in the respective communities where we live, I'm at the University of Kentucky. I can imagine the school newspaper will contact me and will say, what did I think about this or something like that? And so I want to make sure that I've looked at the general statement so I then don't say, well, I agree with these recommendations, but I slightly would have said the general statement a little bit differently. I'd like to make my comment about the general statement in front of all of you, and then we hash that out as well.
Dr. Wright, I think that's a fantastic idea, and I think we can come together on November 22nd, and as part of the conversation about the recommendations, we can either individually propose or somebody can sort of take the lead on putting together or assembling a general statement. But your idea is a good one. And we can make sure that we fashion some sort of general statement that could, function perhaps as some preamble, if you will, to the recommendations that we all agree on. But yeah, terrific idea, and that'll be something that we can. If you, I don't want to push this on you, but if there's something in addition to the recommendations that you want to put forth, if you want to put a general statement together for everyone's consumption and thought as we go into this next meeting, then that sounds good, or we can take a stab at it.
Yeah, if you don't, I'm smiling when I say that because I don't, if you don't mind taking a stab, but I was trying to think back to when we first got together. I suspect there was something that was said then. I don't recall now that may have said, this task force is meeting and we're going to do something or the other. And I don't see that we've had any great disagreements or anything like that. But as I say, I can just see somebody saying something to somebody that we then it would almost then look like, oh, we had that. So if your office or I'm going to ask Mr. Blake Christopher or whatever, maybe he can give that a shot in that regard. I'm real good at telling somebody whose ideas I don't like. I'm less good at the other way around.
I think that's a task for a professional educator. Do we have any professional educators?
But all right, well, we will take the hint, and we'll work on getting something together, and we'll have that prepared and ready for
okay.
Second meeting. All right, if there's no further conversation or discussion about this November 22nd meeting and putting forth the recommendations for discussion, I will move to the breakout of the subcommittees. And who wants to brief first? We can go with securing, serving, or reviewing. Whoever wants to do it
The
first.
serving committee met and we have come to agreement with the recommendations. We will be submitting to Blake Christopher by the end of the week, so they'll be ready for the 22nd.
Thank you, sir.
Securing committee met, and we on the recommendation of Judge Cunningham, which I think was a great recommendation, we're going to send over what we want to see as mandatory changes, best practices, and aspirational. Okay. And we're working on categorizing those and finishing them up, and we'll have something to call.
And on reviewing, I have a couple of comments. One, we're going to have 3 recommendations very quickly. It's the recommended data collection for search warrants for further evaluation in the future. Chief's accreditation, some training for that. And then we talked about prosecutorial review of search warrants since it's recommendations and not a mandate because it's different in different types of communities. I will say as chair of the Judiciary Committee, one thing we discussed was once these are all compiled, we probably, if the Attorney General would like us to do so, we'll try to compile something and put it in the form of a resolution that would kind of do what the gentleman said. I think that in addition to giving credence to the task force and the meeting and the work we've done, if we could get the legislature to do a resolution and buy into that, I think it shows more of a global response to the situation we're dealing with. And then it would also give, I think, some more credence and more stamina to the task force work that's been done. So I'll have to review that with Chairman Westerfield, of course, but at least on the House side, that's kind of the way we would think about it. So going to what he was talking about with language, we could kind of start a process of how we would draft a resolution to that piece.
That sounds great. Thoughts on that? All right, any additional comments or questions as it relates to those breakout briefings? All right, anybody from the public chimed in online or anything? Okay, so you all know the November 22nd meeting. Anybody here have any additional ayes have it. Thank you guys so much for being here, and we'll see you all next Monday at 1 o'clock.